If you die in Florida without a will, the state already has a plan for your estate. The question is whether you would agree with it. When someone dies without a valid will, they are said to have died intestate. In Florida, intestate succession is governed by Chapter 732, Part 1 of the Florida statutes. The law decides who inherits based on family relationships, not personal wishes, promises, or what relatives believe the person wanted. First, know what these rules control. Intestate succession applies to probate assets, property owned in the deceased person's name alone with no beneficiary designation, no surviving joint owner, and no trust directing where it goes. Life insurance or retirement accounts with beneficiaries, many jointly owned accounts, and trust assets usually pass outside intestacy. So, for the probate estate, who inherits? Florida starts with the surviving spouse. If there are no surviving descendants, the spouse receives the entire intestate estate. If there are descendants, meaning children, grandchildren, or further lineal descendants, the result depends on the family structure. If all of the deceased person's descendants are also descendants of the surviving spouse, and the surviving spouse has no other descendants, the spouse still receives the entire intestate estate. But blended families change the outcome. If the deceased person has descendants who are not descendants of the surviving spouse, the spouse receives 1/2 of the intestate estate, and the descendants receive the other half. The same half-and-half result applies if all of the deceased person's descendants are also the spouse's descendants, but the surviving spouse has other descendants from outside the relationship. If there is no surviving spouse, the estate passes to the deceased person's descendants. If a child is living, that child receives a share. If a child has died but left children, those grandchildren step into their parents' place. This is per stirpes distribution under Section 732.104. If there are no descendants, Florida moves up and outward through the family tree. Parents come next. If there are no surviving parents, the estate generally passes to siblings and descendants of deceased siblings, then to more distant relatives, under Section 732.103. Half-siblings are not ignored. Under Section 732.105, relatives of the half-blood inherit half as much as relatives of the whole blood in the same degree. And if no heir can be found, the estate ultimately escheats to the state of Florida. Florida intestate succession is a default plan. It is orderly, but it is not personal. Without a will, the law may answer the inheritance question in a way the family never expected.